Yes, friends, this is part 2 of Powers of Directors, where we have seen up to section 183, the powers of the Board of Directors to make contributions to National Defence Fund. Now, friends, we will look at another important provision, section 184. 184 pertains to the disclosure of interest made by the directors. Disclosure means that if a director is interested in a particular transaction, contract, suppose his son or son-in-law or daughter-in-law, wife, they're all in fact happen to be the contractors and the contract has to be awarded, the fact has to be disclosed by the director to others and in the board meeting, and you should not sit in for passing any resolution, and others disinterested directors will have to approve it. Only then that will be true and binding on the company. So here section 184 plays a very pivotal role and it stipulates the various rules, do's and don'ts thereon. So this is another important subject matter I request you to go through thoroughly. Followed by section 185 pertaining to loans to directors, where loans can be granted. Normally it cannot be, but there is a particular provision that by passing a special resolution it can be granted, and there are other rules and regulations stated so under section 185 of the Companies Act 2013. Then friends, the intercompany loans and investments are stated under section 186. Normally this could be a 20 marks question wherein certain percentage has been stipulated thereon, and then the rules are made by the central government, and then this would be one of the important topics. Then under 187, the investment of the company to be held in its own name, and 188 deals with the related payments. And then, so these are all the basic issues. In fact, I request you to study further, and then I don't have to go into further details. You can go through the provisions. Wherever there is a controversy, there is a discussion required, and there is judgment of Supreme Court, I feel I should bring it to your notice. Then, one important provision under section 196 I would like to tell you. That is, a company must have only a manager or a managing director at the same time, but not more. Remember, here manager means not the service manager, finance manager and accounts manager, marketing manager, sales manager, no. The manager is here company law manager, section 196. More or less the same provisions of the 1956 Act have been repeated in the 2013 Act. That a company cannot have both a manager and managing director together. That means the difference is that a manager is not a director, a managing director is one of the directors of the company. That's simple as that. And then the company cannot appoint or employ at the same time managing or managing director, and no company shall appoint or reappoint any person as its manager, full-time director or manager for a term exceeding 5 years at a time. And then provided that no reappointment shall be made earlier than 1 year before the expiry of his term. These are all the basic terms, and the conditions are concerned. The age is concerned, it should be, in fact, it should not be below 21 and above 70. And appointment of a person, suppose who has attained the age of 70 years, can be made, of course, by passing a special resolution, in which case explanatory statement has to be annexed to the notice for such motion, and it indicates the justification for such appointment. Then he must be, he should not be an undischarged insolvent or at any time has been adjudged as insolvent, and then that means basically no company shall appoint a person as a managing director, whole-time director or a manager who is an undischarged insolvent or has at any time been adjudged as insolvent, and then at any time been suspended payment to his creditors, or has at any time been convicted by a court of an offence, sentenced for a period of more than 6 months. So these are all the disqualifications to be taken into account while appointing this particular personnel. Then section 197 deals with the overall maximum managerial remuneration and managerial remuneration in case of absence of inadequacy profits. This is dealt with under section 197. And then the overall percentage fixed here is 11%. And then actually this is another important aspect with regard to the managerial remuneration aspect. And then friends, the other provisions are concerned. The section 200 would enable the central government to fix a limit with regard to the remuneration, and then compensation for loss of office, a managing or whole-time director or manager is dealt with under 202. And then under section 203, the appointment of other key managerial personnel like the, in fact, company secretary, chief financial officer also dealt with. Then the managing director or CEO, chief executive officer or manager, in the options a whole-time director also is dealt with here. It could be made by the articles or otherwise, and the company secretary is stipulated under 203, read with 204, and further 205. Here the company secretary means the person who has passed the examination of the Institute of Company Secretaries of India alone can be appointed as a company secretary. And the functions of the company secretary are stated under section 205 with regard to reporting to the board the compliances, ensure the company complies with all the requirements, discharge other duties as may be prescribed, and the secretarial standards thereon, and so on and so forth. So friends, with this particular background, we conclude our discussion on the duties of the directors, powers of the director. The powers of the directors. And then in the future classes, we'll deal with other topics in course of time. So thank you very much. Good night. Bye-bye.